A couple more minutes before we get started. Everybody can join a little bit. We are recording this. And good morning. It's just for, we've all been doing Zooms now for what now seems like a year, and hopefully we'll keep doing a few Zooms, but we'll be back in person soon enough. So as you have questions, you can go ahead and put them in either the Q&A or in the chat function. Either one will be monitoring them. And Daniel and Clif will be looking at them as they go along, and we'll then take questions at the end. But I want to welcome everyone to this webinar from the San Diego North Economic Development Council. We've been doing these since the pandemic started on key topics that matter to North County prosperity. We are excited today to be joined by Daniel Brunton of Council, from Latham & Watkins, and Clif Williams, also from Latham, who is a land use analyst down there. They're going to talk about CEQA today and some of the changes that are important to think about project proponents and also agencies that are analyzing environmental documents. Just to give you a couple of heads up of future SDNEDC events. Next month, looking like June 15th, we're going to be doing a webinar from Polito and Epic, along with another partner of theirs, looking at the research and development tax credit and the employee retention tax credit, and how small and medium-sized North County businesses can take advantage. October, we're planning on relaunching our Lunch and Learn series. So that is an in-person monthly luncheon that we have. We anticipate to be back at the Green Dragon in Carlsbad the last week of the month, probably the last Thursday of the month. And then December 16th, people probably have gotten that on email, so save the date for our third annual Excellence in North County Economic Development Awards Luncheon. That will be at the Seabird Hotel, the new resort, which is opened up at Oceanside. It is a fantastic property. I cannot recommend it highly enough, and so we're excited to be bringing a program there for folks that are a little bit longer in tooth or have gray hair like I am. Know the saga of getting that hotel built, and it's fantastic that Malkin has put that together and that it's flagged as a Hyatt property. With that, I'm going to go ahead and turn it over again. Daniel and Clif, they're going to go ahead and share the screens and give us a 2021 CEQA update. Daniel, Clif, thanks for doing this, and the show is yours.
Terrific. Thank you, Eric. Can you see the slides?
I can, and everything looks good. I'm not seeing any problems in chat.
Terrific. Yeah, thank you for that introduction. I'm Daniel Brunton. Just a little bit about our background. I am counsel with Latham & Watkins. I've done environmental law, focusing on land use for 20 years now. An emphasis on CEQA practice and NEPA, helping developers get through the entitlement process in a large variety of projects. And then also I litigate and defend those entitlements. So we bring a unique perspective, sort of cradle to grave, we like to think.
Yeah, and I'm Clif Williams. I'm a land use analyst here at Latham & Watkins. I've been here at Latham actually now for almost 16 years. I came out of the city of San Diego. I was the chief of staff for the city council president, and also worked as the committee consultant for the Land Use and Housing Committee and the Natural Resources Committee. So I come from a government standpoint. I'm not a lawyer, but I've worked in the land use field for a long time, read a million EIRs, and work on the practical thing. In this instance, I think of us as like the Property Brothers if we're doing this kind of thing, where Daniel's gonna make sure that you build your house and make sure it's all to code and that it can withstand an earthquake, and I'm gonna sell your house and deal with all of the permitting and stuff that goes along with it. So that's kind of how we work on these things. So we'll get into it here. So the first thing, just starting, and we know that there's a lot of different people on this seminar. We saw on the list there that there are land use lawyers, there's developers, there are CEQA practitioners, just interested business people. So this, we're setting this up. We're going to go over some of the important emerging issues in CEQA. Then there's going to be kind of a denser section in the middle that deals with some of the newest cases. And then we're going to end with best practices on how to really keep your EIR in good shape. And really, when you think about what CEQA is in the most basic sense, is it's an informational document. It really provides the government with a way to make that discretionary decision. And it does apply to pretty much every discretionary decision. And one of the first mistakes that sometimes a public agency makes is not doing CEQA related to a discretionary decision. So that's something that has to be looked at very closely. But it's an informational document that looks across all of the different types of impacts from air quality to traffic and so on. So, and this is a great quote that kind of says what the heart of CEQA is.
And then, of course, how CEQA differs from NEPA and is kind of an action forcing statute is there's a mitigation requirement where an agency identifies significant environmental impacts. They need to identify potential mitigation and either adopt it or show why it is not feasible. There's the legal reason from the agencies and the public standpoint of what is CEQA. Then there's the practical aspect from the developer's perspective.
Right, and that's that. CEQA is that place that you go to the city council or the planning commission with your CEQA document, with this informational document, but it's also the main point of legal challenge on these land use decisions. We used to say, at the city that there were sort of two levels of approval. You have your city council approval, and then you have your judge approval. So your judicial approval. So this is where the litigation occurs, and it can be expensive and time consuming.
And the overall process, I mean, the CEQA process, the EIR process, when things are going well, I would say a year minimum to 18 months. When things are going quite quickly, litigation then, the courts have been backed up with pandemic. Litigation is never fast. Through the Court of Appeal, I would say, 3 to 4 years. So you're talking about a multi-year process. And then, I wanted to talk a little bit too, if you do an environmental impact report, there is the sense by a lot of agencies and people that work in the field, I think, that you're home free. And the environmental impact report is more litigation defensible than a negative declaration or doing an exemption. But we did some analysis on recent cases, and there's some interesting trends that show just how technical and how many traps there are, for the unwary for this. In 2020, there were 34 Court of Appeal opinions. We divided them into different categories. EIRs is probably the main one to look at. That's the environmental impact report, the main report that an agency does under CEQA. And this is just some more statistics, but the interesting aspect of this is public agencies only win in about 60%, 58% of environmental impact report cases. So think about that. You're a developer, you spend a year and a half plus, usually plus, some X hundreds of thousands, probably millions of dollars working on getting through the process. 40% chance of getting your EIR overturned if there's a lawsuit. Obviously not every project gets sued, but so part of what we're going to do today is give you some trends to keep your eye on, but also to give you some practical tips to make sure that you're in the 60% of cases that prevail on the EIR defensibility.
Yeah, and to the practical aspect of that, one of the things that I do a lot of diligence for banks and lenders that are coming in and looking at projects. And when there is CEQA litigation pending, or when you have a project that has a well-resourced opponent, they're folding that into the cost of money when they're financing a project. So and looking at that risk, because of course risk means a higher cost of money. So that's one of the sort of the practical aspects of how CEQA litigation plays in here.
Yeah, it's leverage for project opponents. It's the point of maximum leverage where they can add years of delay and expense. And maybe not always, but I would say a lot of times, if there's CEQA litigation, it's difficult to finance a project. People are not going to go ahead with a project. And this is just another way of kind of looking at the statistics. So we're going to talk about emerging issues.
So these are some of the big emerging issues that are coming out: greenhouse gas emissions, the VMT, and the environmental justice. And just on the first one, greenhouse gas emissions. Obviously, this is something we've been talking about for a while. But I think what's emerging is that greenhouse gases and climate change have really become the central policymaking issue for the state of California. And so that then bleeds into everything from your air quality standards. It goes into this vehicle miles traveled thing that we're going to be talking about, and it goes into environmental justice. So it's sort of the center that everything is springing from. And just so to make sure everybody's understanding that, it's greenhouse gases, it's global warming, and that is settled science. There were a few jurisdictions that were sort of still fighting that, but it's not a good thing to fight that at this point. The state of California has settled that science. So even if you don't believe it, the policies say that you have to work through that. And in the most recent CARB scoping plan, they're looking to reduce GHG emissions by 40% below 1990 levels by 2030, and then an 80% reduction by 2050. So you can see where the policies are going. And CEQA requires now that we do an actual analysis of the GHG impacts. And a lot of jurisdictions have created, and the CEQA guidelines allow for this, the creation of climate action plans, which is how you can show whether or not you have a significant impact from this. And if you comply with the climate action plan, then you're found to you don't have a significant impact. However, we just want to caveat this with developers should be really diligent in the way that they look at these climate action plans and take a little bit of an outside look to make sure that they are supported by substantial evidence.
That's a great point, Cliff. And I think just to emphasize, as a practical matter, these climate action plans are great for the developers, for the agency. They really do streamline things when they work. But you have to understand you're tied then to a program that if the program is under challenge or has problems, you need to understand that. And sometimes, I don't think this will be often, but sometimes developers may need to choose to do their own backup greenhouse gas analysis in case there's a problem with a climate action plan, especially when there's a climate action plan that is under challenge. I think in the San Diego region, and you're going to make a comparison a little bit, but I think for a lot of these there is a great deal of goodwill towards the climate action plan and the environmental community and desire to see them work in most jurisdictions.
Right. And that's actually going on to the next slide. I think that's a great way to sort of look at these, is that these climate action plans have been embraced by groups like the Climate Action Campaign, and they have been pushed in all of these different jurisdictions. I put City of San Diego, San Marcos, Oceanside, Carlsbad, Oceanside, all up in North County, have these checklists. And these are climate action plans that have really been endorsed by the environmental community. And they essentially look at, do you fit within the framework of the general plan that is in existence? Because usually they've done these greenhouse gas emission studies and inventories based upon what's there and what's planned. And then it's saying, do you add to that? And if you do add to that, then the next step is, are you in a transit area? Are you close to these trolleys that you see here? And if you're there, then you don't have those same impacts, because people have an opportunity to hop on a trolley and get from place to place. So you don't have the impacts. But then even so, you're still going to have to do some things like green roofs or energy efficiency and things like that. And they have a list of those things. You have to check off those things that are included. Most of those things in California, frankly, are built into the building code and stuff these days. So a lot of it already works. But as a practical matter, if you're doing a large project in San Diego County these days, make sure that you have renewable energy component, that you have these things that are built into your project already so that you can say, yes, when I get to the checklist. The other way of doing it that is sort of happened recently is the County of San Diego, for example. County of San Diego's climate action plan has been under challenge, frankly, since the early 2000s and was recently overturned again. The county general plan actually had a requirement for a reduction in community-wide GHGs. So it actually said that the policy was, we're going to reduce our GHGs here in San Diego County. But the problem with the CAP when they created it was that it allowed for out of area offsets. So if you couldn't do it here, they said, then you could go and plant trees in Brazil or do some other type of project that was out of area. Sort of like when you get on a plane and you buy GHG offsets, on a website. And the court said that this wasn't enforceable and that it really deferred the mitigation because it said that we're going to figure it out later. And that was the problem with the county's CAP and this general plan inconsistency. So they're going back to the to the drawing board and creating a CAP, and it is likely that it will look more like the checklist that you see in other cities.
Yeah, great point, Cliff. And there's nothing, as the CEQA litigator lawyer, there's nothing wrong necessarily about out of area offsets, and it's something endorsed in California law, but the county was, essentially doing it wrong. It's also worth pointing out there's been some change politically in the county, and we're kind of a new world where I think these ideas of VMT is next, where let's just skip to that, are more embraced in the county. Previous approach was a bit grudging, shall we say.
Yeah, and so we're into this new world again. Greenhouse gases now are going into traffic analysis. Traffic analysis used to be how fast can I get from point A to point B or through an intersection within how many seconds, and that was the LOS standard, the level of service. So you had your street segment and how fast was I going to go move down that street segment or move through that intersection. We have completely changed now. With the passage of SB 743 and the vehicle miles traveled standard, what we're looking at is not about congestion. We're looking at how long does it, or how far are you from work and where you live, which is a really big change. And the CEQA guidelines now say that if you are less than half a mile from a big transit stop, like a trolley or a major bus line or something like that, you're presumed to have less than a significant impact. Because that's really about greenhouse gases, and it's about from getting from your house to the place without getting in your car. It's not about how fast your car is moving on that freeway. And on the next slide here, that's sort of the thing. The standard that they're looking at in most jurisdictions here is a 15% below the per capita VMT or per employee kind of VMT. And but to bridge the gap between this notion of cars moving and saving of greenhouse gas emissions, a lot of jurisdictions, including the city of San Diego, require a local mobility analysis too, which is about operational movement. It's going back to that sort of that LOS standard, so that you're going to really have to deal with both in a lot of CEQA stands. You're going to see these operational issues show up in the safety elements of EIRs, public facilities sections of EIRs, maybe not in the traffic section.
So almost just like the CAP analysis and the greenhouse gas that we were just discussing, this VMT is a streamlined approach that in a lot of ways is easier than the old way of doing LOS. You just look at your area-wide VMT, compare the project to that. In the old days, you had to chase out trips and figure out how far you were going to follow them and which intersections would be impacted and whatnot. So this is a lot easier, but we're still groping through this. In some jurisdictions, it's not just the new approach, but you have to do the old approach as well. Another interesting aspect of this, and it's just something that I note, is the VMT doesn't seem to account for the increasing electrification of mobility, right? It's like, if we're all driving electric cars, is it so bad, if we're driving farther? Obviously, that's a policy decision that the state of California has decided, but it'll be an interesting discussion to see, is that revisited? During the pandemic, I know a lot of people have kind of looked at their lifestyles and seen, thought about wanting some more space. Clif, I know you actually moved during the pandemic, and a lot of us are happy to have single family homes and be able to spread out a little bit. And it'll just be interesting to see. I think California before the pandemic was really pushing towards more multifamily homes, and it'll be interesting to see just how this shakes out.
Yeah, and that's really it. And here again, we see the policy framework of the state of California, how it bleeds into everything. So, whether or not you buy into this, or you believe this, or you're a traffic engineer that believes in congestion versus VMT and things like that, CEQA doesn't care. What it's saying is that we are implementing what the state has done, and so you have to do these types of analysis. You really just don't have a choice.
Environmental justice, another big emerging issue that's been out there for a while, but now it's becoming more real. It actually, Senate Bill 1000 in 2016 required environmental justice elements in general plans. This is being implemented now. I know the County of San Diego is working on it. The City of San Diego is working on it. The cities and counties have a bit more time. They have, whenever there are 2 or more updates to general plan elements, they have to implement an environmental justice element. For the City of San Diego, for example, they're expecting in 2022 to have the environmental justice element. It's not clear exactly what an environmental justice element will look like yet and how it'll affect CEQA analysis, but it's potentially a big deal. This is guidelines and a reference to the statute from OPR, which helps jurisdictions implement their general plans. And you can see it is sweeping how broad some of these issues are. And I think everybody cares about having a more just, equal, better community for everybody. The question is for, practitioners, are some of these things so open-ended and amorphous that it's just an invitation to litigation? It's not, contrast it to the traffic, for example. It's easy to tell, or it may not be easy, but it's a quantitative numeric threshold to be able to tell, are you 15% below the regional average for traffic? Compare that to, identify objectives and policies to promote safe and sanitary homes in disadvantaged communities. Is your project doing that? How much is enough to do that? And if not, are you going to be subject to litigation? So I think, to be decided, but this is something to keep your eye on, and I think it will ripple through to everything.
Yeah, and I think, again, going back to the top of our emerging issues with greenhouse gases, as I was actually driving here, there was a report on KPBS radio talking about how the county is going to be creating an office of environmental justice and climate. So climate really becomes the driving issue behind environmental justice, and like greenhouse gases, I think is becoming a central policy issue that will then bleed into all of these different areas that you see on the screen here. So you're going to start seeing it, popping. Once you have general plan policies on these different things, then your land use section has to look at how you are consistent with the general plan. Therefore, you're going to have to look at how your project complies with these policies.
And our 3 emerging topics are really linked. You could almost have a single environmental justice, VMT, GHG, section of an
Exactly.
EIR. I'm going to talk about a couple of recent cases. I'm going to try to keep this not too dense. There were a lot of cases. I'm just going to touch on them, and I will refer you to our Latham and Watkins website, where we did a complete analysis of all the cases for 2020, and we'll do the same thing again for 2021 if you're interested in this more dense look. But there were a couple that we just had to touch on, and then Cliff and I are going to talk about some practical issues. This one, Dunning versus Kevin Johnson, case here in San Diego County, actually city of San Diego. Very interesting case. The developer and city prepared a negative declaration for a small school. The developer in this case was a small school. Neighbor sued challenging the negative declaration. The developer and the city could tell not motivated by environmental issues. There's other stuff going on here that's motivating the case. Common thing to see. I can't say how many times I've had clients say, you know, this is nonsense. The opponents are not motivated by environmental issues. How do I punch back? How do I hit back? In this case, the school owner sued the neighbor who challenged the negative declaration for malicious prosecution. In California, we have an anti-SLAPP statute, which is designed to protect folks from lawsuits when they exercise their First Amendment rights. And the neighbor brought an anti-SLAPP motion, but the Court of Appeal held that the developer had made a prima facie case for malicious prosecution. That's a lot of procedure, but the bottom line is this is a case that held there's an opportunity to sue project opponents who bring malicious CEQA cases, sue them for malicious prosecution. Basically, you would get your damages for having to defend their case. How will this unfold? Is this going to be an outlier or beginning of a trend? I can tell you it was a Justice McConnell opinion. Terrific justice, lead justice in our local Court of Appeal. So in that extent, well-reasoned opinion and published opinion. There were some facts in this that were pretty extreme. We'll just have to see how it unfolds, but it is something that I would give pause if I were somebody trying to use CEQA for non-environmental purposes and dressing up, trying to dress up other concerns cloak them in environmental concerns and bring a CEQA lawsuit, which does happen, was found to happen in this case. So interesting development. We'll have to see how it unfolds. Do we see a lot more of these, or is this a one-off given its fairly extreme factors? Here's another case at Save Agoura, Cornell, Knoll versus City of Agoura Hills. And this is a case, really a demonstration of the power of an environmental impact report as opposed to a negative declaration. And I think Clif touched on this before, but one of the early decision points that you have when you go to the CEQA process is, do you do an environmental impact report, which is longer, costs more money, but is easier to defend, or do you do a negative declaration? It's up to the lead agency. So you don't always get to choose. It's up to the lead agency, but so often we find ourselves advocating for an EIR or, encouraging clients to go for the environmental impact report because of the more favorable standard of review. And here was a small project, 35 units, some mixed use, a little bit of mixed use. It was on 8.2 acres. The developer used a mitigated negative declaration. And essentially what happened is California Department of Fish and Wildlife submitted some critical comments. there was conflicting evidence in the record. And when you prepare a negative declaration, when the lead agency prepares a negative declaration, those conflicting evidence in the record situations, they're going to go more often than not, with the plaintiff. So important. Yeah, go ahead.
Yeah, and I was just going to say on that one, we see this very often where in smaller projects like the Agoura Hills project, a public agency will say things like, "Oh, it's not a big project. Let's just do an M&D." The developer likes it because it costs less and it's going to get them through faster. The problem is that on the back end, it could cost you time, it could cost you a loss and a legal challenge, and having to go back and do the EIR anyway. And I think when you're doing an M&D, most of the time, you've done a 70% EIR, so you've done a lot of the analysis. It's really cooking it to the consultant reports and things like that. So if you do have any reasonable challengers out there, it's probably best to do an EIR.
Yeah, and that's a great practical point that a lot of times you see negative declarations that could be repackaged into an environmental impact report, and you get the more favorable standard of review. So one more case here. It's a dense case. This was a 70-page opinion, but it is a blockbuster. I'm just going to touch on it. There's a lot of text here. I'm not going to read it all, but the reason I think this case is so important is you think about there's a CEQA plaintiff's bar, and they're looking for the next thing. They're looking for the playbook. And this case was a long, well-reasoned opinion, published opinion that gives the playbook for challenging mitigation measures. And County of Kern adopted an environmental impact report to address local permitting of oil and gas exploration. So it was sort of a county-wide program. And I'm going to just kind of skip through here. There was it was going to be thousands of oil and gas wells over a number of years. So as you can imagine, the mitigation was fairly involved and detailed. Multiple mitigation measures got struck down. And I think this is going to be the beginning of an extended discussion in the case law, about mitigation, and that CEQA plaintiffs will try to use this as a roadmap. Water supply, and just to kind of give big picture, and I'm again not going to go over all of these, but big picture, you've got to have the evidence that the mitigation is actually going to work in the environmental impact report. And CEQA requires lead agencies to mitigate significant impacts to the extent feasible, but the agency needs to do the work to show what that mitigation actually is. So an example here is the County of Kern just adopted for some of their mitigation the language straight out of the statute, that they would basically, they called a mitigation measure that the project would mitigate to the extent feasible. And that wasn't enough. They weren't showing their work, so to speak. Other things, other sort of squishy type measures that got turned down would a mitigation measure requiring the county and applicants to work together to develop a plan. It's just too, it's too diffuse. There's nothing showing that it would actually work. There are some other examples here. One interesting one, I know some of you probably watched the County of San Diego Board of Supervisors hearing yesterday about the VMT. I know there was a discussion about mitigation, mitigation fees. This too is a hot topic, mitigation fees, whether or not that works. And there was a mitigation fee in the County of Kern program. There, the county basically said, pay us the fee, we'll figure out the program, we'll figure out how to mitigate it in the future. That sort of mitigation fee doesn't work. what we have seen contrasted to like city.
Yeah. So like in the city of San Diego, for example, in like the University City area, you have what's called an FBA, a Facilities Benefit Assessment. In that case, you do pay a fee, and that fee goes to pay for a myriad of different programs. However, those programs, if you actually look at the FBA book, they're all laid out there. It says, you know, traffic program 1 is this street and adding lanes. Traffic 2 is adding an intersection at this place. Number 3 might be adding a new interchange with the freeway. And it has a timeline for when those will be built based upon when they assume the development will be coming forward and it will be needed. So it's a very objective way of looking at. And so the money, even just you're paying your fair share, but you know exactly where the money is going and when it will be spent and how it will be spent. So there again, you're locking your mitigation to a logical conclusion and fee program.
So I'm going to skip through the rest of this. Again, for those of you who are interested in the more dense look at all of the cases, if you go to the Latham and Watkins website, we do have, you know, we've gone through all of them. Now to end it, Cliff and I want to talk about some practical lessons. And this is to get you into that 60%, you know, in 2020 of the EIRs that were legally defensible. And this really is the nuts and bolts of, you know, what we do in the process. There's both navigating the process, getting to a hearing, getting your project approved, but then you also, as you're doing that, want to have defensible.
Right. And you know, as with the emerging issues are always interesting, but these are the practical standbys that really come up over and over and over again. And the first one here being that we need to support our conclusions with substantial evidence. Like in that mitigation case we were just talking about, you need to hook there needs to be a logical A to B to C to D. You just can't jump from A to D and assume that people kind of understand what happens in the middle. And that means hooking your conclusions to an analysis that was done by a consultant, and then that analysis is provided in the EIR, so that you're making in the don't, you're not just saying the biology consultant couldn't get out there, but we either think fairy shrimp are there or we don't think that they're there. In fact, you actually did the protocol study. You found that they were there. That protocol study is in Appendix A, and based on the results, there were none there, and that's why. So it seems something that everybody would just do, but you really need to explain yourself. That's kind of the bottom line.
Avoid sloppiness. This is a big one. And I think, you know, in the 20 years that I've been doing this, first, you see a lot of sloppiness that causes problems. Just, you know, I would say 20 to 30% of losses and problems are not like big technical issues. It's just sloppiness. But I would say that in the 20 or so years that I've been doing this, I think the standard for consultants and EIR preparers has gotten better. I'm just impressed by, you know, a number of the folks that I've worked with in recent years, and it seems like kind of the cream has risen to the top. But you've got to think about the process of preparing an EIR. You'll have a developer who may be iterating their project design as the environmental impact report, this long document, is prepared. And the document needs to be updated to track the project, track the different analysis. And, you know, so many times you will see just inconsistencies that cause problems, and that can cause losses.
Yeah, we often, I mean, it's not uncommon when an EIR has been developed over a 2-year period to see something that maybe somebody who was originally on the project early on put into a section, and then the project changes a little bit, maybe just because of public opinion, and then they don't change that thing in the earlier analysis, and it just is inconsistent. And it's an easy thing for the opponents to point out. So here again, using the right baseline, we all want to say and the right one is ground to plan. What's there now and what are you going to do? Not what can you do and what are you going to do? And that's really the big deal. And there's a lot of, arguments are always made. Well, we could build a 200,000 square foot building. We're only building a 150,000 square foot building. So we're just not going to have any impacts because we're less than what was going to be there. That's not what CEQA requires. It requires you to look at, if it's bare ground right now, look at that bare ground and what are you adding to it? And that's really, and oftentimes they do look at the plan, the zoning, the general plan, things like that. And you can't do that.
Yeah, well, you can say it, but you've got to do both when you do your actual analysis. And, the other thing on this baseline, kind of an interesting issue for pandemic, because on certain things, traffic was way down. And I think, I'm seeing projects use pre-pandemic baselines and data just because pandemic data oftentimes wasn't available, but may also be misleading. And that just needs to be supported by, substantial evidence. There are some case law saying that, you can deviate from ground to plan in certain instances where it would produce a more, realistic analysis. I'll take this one, improper deferral of mitigation. Again, comes back to mitigation. In addition to the emerging topics, if there's one thing that I could emphasize from today, it's the mitigation is going to be a target for litigation. Just the King and Gardiner Farms case, again, is the template, the playbook to challenge mitigation for projects. And I think, every CEQA case law, every CEQA case going forward is going to challenge, mitigation in some respect or another. So you've got to button it up. It's okay to have some deferral, but improper deferral is what you want to avoid. And deferral is okay when you have a standard in the example here, to say mitigate noise impacts to a certain dBA. But when you leave it open, just say there's going to be a future plan, mitigate according to that. That's improper deferral and will get overturned.
So in this is one that is consternation over this one. If there's already a problem, so in the do's and don'ts here, we have a PM10, which is a particle size of diesel particulate. If you already are in non-attainment for these diesel particulates, and your project's very small and it's not so big, but it will add something to it, you can't just say it's not significant because you just added a little bit. Sometimes adding a little bit of salt to a recipe changes the taste of it. And that's really what this is about.
Yeah. And an example of where people used to do this when greenhouse gases really was more of an emerging issue, you'd see analysis that said, well, California is only X% of global greenhouse gas emissions. This project is only blah percent, it's a tiny fraction, therefore it can't be significant. Being a small amount doesn't mean you are significant, but it's not, you can't just base finding of non-significance on the fact that you're adding a little bit. You've got to go beyond that. And, particularly where there's an identified cumulative impact. Include all aspects of the project. And this happens more often than you would think, that things just get omitted. Most common for offsite infrastructure and future phases of the project. Again, work with the developer, understand the project early on, and identify all pieces of the project.
In this one, this is sort of goes to a little bit to that sloppiness thing that we had, as well as actually identifying the threshold of significance. One of the nice things that a lot of agencies have is they have very defined significance thresholds. And when those are there, it needs to just be defined. You need to put it there. This is what our standard is that we are looking at, and then show how the project did that analysis, and then make a very clear impact statement. It's significant. It's not significant.
Yeah.
Don't have this kind of mushy language. Oftentimes, people sometimes feel that they need to put it in their own vernacular. You don't. Use theirs.
Yeah.
Use their exact language, and then do the analysis and be very clear.
Yeah. Another one to come back to mitigation measures. Now, this is an important one. If you have a project with significant environmental impacts, favorite playbook of opponents and, well-intentioned people who just want to comment on a project too, is to propose mitigation measures for the environmental impact. The lead agency needs to go through the mitigation measures and either adopt them or reject them. And if they reject them, they need to explain why they're not feasible. So that's part of CEQA's, action forcing potential there that really, encourages lead agencies to adopt all feasible mitigation measures.
And I know we want to leave some time for discussion, so we're going to move through these last ones here pretty quickly. The next one here. So failure to analyze the impacts of mitigation measures. Again, if you have to build a freeway interchange for your project, that freeway interchange needs to be a part of the project, and you need to actually analyze that. So, and then improper fee-based mitigation. Again, this is sort of going back to that King County one that we just looked at. If there's a fee-based mitigation program, it has to be something like the FBA that we talked about, where there's an actual program behind it, not just we're going to collect fees and we're going to put it towards transportation and we know best how to make all that work. It just has to be hooked to something.
And then including a reasonable range of alternatives. And this is a one where sometimes the project proponents resist. They know what they want to study, or they know what the project that they want to build, that the demand is there for. But it's important to have a range of alternatives and, including a reduced density alternative. Again, it's a changing world. Density in the right place is not always, viewed as bad anymore. It can be a good thing to have density. But you want to have an alternative to address the different significant impacts.
File those notices. This is a case that recently came out and having to do with the statute of limitations. And I will tell you, just from a practical matter, because I do this, is that you need to file the notice of determination after the agency makes that determination. And once you file that with the county, or the city or the county files that, that starts your statute of limitations time period. And these are so important. We have had cases where they waited a week to file that notice of determination. We started our clock pretty much right after, and then you find out that the notice of determination wasn't filed, and it, they did actually file within the right thing. Also, if you don't file these on a negative declaration, there's a 6-month statute of limitation, 180 days that you look out. And so at the end, 6 months, you're actually getting ready to build the project. You suddenly can get hit with a CEQA lawsuit that you didn't even know was going to happen. It's a big deal.
Yeah.
And then lastly here, we have, I came from the public sector and came into a law firm. And I will tell you, I learned quite a bit by coming to the law firm. And one of them, the first thing here is to bring on a land use attorney in the beginning, so that you're actually having somebody like Daniel develop the EIR, read the sections, read the consultant reports, and understand this stuff so that it can be litigation ready. Don't wait till the end to bring on the land use attorney.
Yeah, really the case and your defense is developed in the administrative process. That's part of the nature of the litigation. In CEQA litigation, you don't call witnesses, you don't develop expert reports, it's based on the record before the agency. So the work that the consultants, the team, your land use attorney, Clif, everybody does, that is the case. So that's the time to make your case.
Yeah, and that's why it is really important that you lay that groundwork for the record, which is, responding to every comment, but saying, I've responded to your comment and here's where it's located in the EIR. Be very clear, and also use the findings. There's findings that have to be made, and that can be an area where you as the applicant can set up a roadmap for the judge when they're reading through that this is what the agency thought about. And so if there's a fork in the road, you tell them why you turned left or right. And that's also where you can bolster the record with some additional information, things like demographic stuff from Sandag and stuff that may be more policy related. That's it.
So we wanted to leave just a couple minutes for questions. I don't know, Eric, if you.
Yeah, I've been looking at them. Thank you guys so much. That was a great presentation and overview of where we're going. I'm gonna try and take these and try and get to all of them. So again, if you have questions or if we've missed one, just continue to pester in chat and we'll go there. Daniel, a key thing that's been going on now for a number of years up in North County is the question of secondary access and fire protection, or fire, safety in communities, especially as projects get bigger. Could you talk a little bit about what you're seeing in respect to both, here and then throughout Latham's caseload statewide? How are people dealing with that issue? And what are some issues going on right now in CEQA, especially if secondary access may be prohibited by other ordinances or other standards?
Yeah, it's definitely a hot issue. And one thing I know, there have been a number of legislative proposals that our clients, following with a keen eye, that would essentially, make development almost prohibitive in wide swaths of the state and the county, where there is very high fire danger. So, on the secondary access specifically, I don't have a project recently that's dealt with that. I guess we had.
I think the Valiano project actually that was overturned in the county of San Diego and the Harmony Grove project, both had aspects of that in the challenge, and the judge did say that wasn't adequately looked at, as I remember. I don't have a specific sort of citation on it, but it again, I think the lesson here is that if somebody is bringing this up as something that they're questioning, you really need to explain why they're wrong or why you are doing it the way that you are doing it. Oftentimes, they will put the fire marshal up there or the fire chief, and he'll say, everything's good, I can defend this fire. That's just not enough to have the fire official stand up there. That might be enough politically, but the judge wants to see that there's an actual plan for evacuating these people in an efficient manner.
Mm-hmm.
Which is interesting, right, Cliff? And again, I think, one of the things I think that has been, and Daniel, you might want to comment about, sort of a roadmap to lay the evidentiary groundwork. The interesting thing, right, is that San Diego, 20 years and earlier, we've had a lot of communities that have had real problems with fire and wildfire based upon, a whole variety of things. There has been this period of time where we built shelter-in-place communities where we have actually evidence from fires where nothing burned, right? And so the question, I think, that becomes an interesting one is, how is an evidentiary record created that's compelling to show that in fact is, that has been the outcome. These are rare events, so we don't have a huge number of fires where we do that, but we've tested those communities and we've seen that fires burned up to the edge and not a structure's been damaged.
Yeah, and I think it's similar to other issues where you have to get your expert, a fire, ex-fire marshal type person to draft the expert report and explain, how that'll work.
Perfect. Okay, great. Let's see. There was, I think you talked a little bit about this, but Daniel, have you guys done any work at Latham on mitigation banking, either with environmental resource offsets? We talked before we started the seminar, we were talking about VMT banks and potentially that. Where are you sort of seeing that trend go?
Yeah, we have. In fact, quite a bit. I actually kind of cut my teeth as a young attorney on a mitigation fee program in Orange County for traffic. And, it's a case of everything old is new again. In a lot of ways, it hasn't changed that much. You've got to show that the mitigation actually will mitigate the impact. And that means showing that, demonstrating the improvements that are needed, demonstrating that, there's a reasonable probability that they will be built, and demonstrating that the funding is there. That orphan share problem of, not enough funding to complete things, I think is a big thing, and one to watch out for as the county and other jurisdictions grope towards some sort of mitigation program for VMTs. It's one thing to pay into a program. It's another thing to pay into a program where there's a demonstration that the thing is actually going to get built, whatever it is.
Yeah, and I think that program that you're talking about is the NIDM program in
That's
Irvine,
Yeah.
which you had the Irvine Ranch that built out over a very long period of time. I mean, the last 20, 30 years. But there is a and because I've worked on this program too, it's a very thick volume that has very specific projects and what will be built as the Irvine Ranch is phased and as it is built. And it is very thoroughly sourced. There are a million appendices to it, and it really walks it all through. And it has stood the test of time, and it's really, they're still using it up in Orange County, even as things have changed, and you get more of that, development, denser development, bigger development towards in certain areas of the ranch. So it has evolved.
Yeah, Cliff, that brings up though a really interesting, Daniel, that brings up an interesting public policy question, right? Which is that to be able, especially in light of the Kern County decision, that, there either needs to be a financing mechanism, or local agencies need to take it on the chin to develop that set of specificity in the mitigation measures, so that subsequent and future applicants and EIRs are defensible, right? And agencies are strapped for cash. And so sort of the last thing that sort of, many of them want to do is send off, 5 planners and a $800,000 consulting contract to develop an FBA or an FBA list for, the next 20 years.
Yeah, that's right. And a lot of these programs, that sort of a traffic program may require CEQA review on its own too.
Okay, great. There was a question. I'll just answer that real quickly. I put it in chat as well. Yes, this recording will be available. We're going to send it out to everybody that registered. It'll also be on the SDNEDC website, so www.sdnedc.org. So that will be fine. I think one last question, and Daniel, again, this kind of talks about that nexus between VMT, GHG, environmental justice in particular, right? So have we yet seen either in case law or in litigation, people making challenges about how mitigation and offsets might, either contribute to better environmental justice outcomes or ignore them, right? So the example that was given in chat was, well, what if somebody says, hey, we're going to do carbon offsets outside the region, and somebody say, hey, environmental justice, that is, missing an opportunity to improve, or environmental justice claims that say on the flip side, hey, the mitigation measures that are being proposed actually have a deleterious effect in another community. You need to not do that.
Yeah, no, that's really more of a policy decision. And, state law is pretty clear that out of jurisdiction offsets are acceptable mitigation, can be acceptable mitigation. So that, planting trees in Honduras, as long as it's verifiable and, quantifiable, that can be mitigation under CEQA. We will see certain jurisdictions wanting offsets locally. In fact, I'd say that's a pretty common reaction in the environmental community, regardless, not just GHGs, like if you have impacts to wetlands, they want to see the mitigation in the same watershed, typically, that sort of thing. So that's almost a general reaction to from the environmental community about impacts.
Yeah.
Mitigate them locally if you can.
And the thing is, though, that again, we can debate the public policy and about this, but the public policy actually needs to match the program needs to match with the public policy. So if you say you're going to do it in San Diego County, you got to do it in San Diego County. If you say we're going to do it as a mixture of things in San Diego County, we're going to follow this protocol, and if we get to this point, it's no longer feasible, and then we can move to the offsets, that's okay. And because the program is attaching to the policy, it's when you get this incongruous logic where you really start to have that problem.
That's great. I guess one last question that I'll throw out there, Daniel, since you put it out, and of course, we're it's just emerging in terms of the lead agencies implementing. Any early indications of where you think environmental justice is how the courts are going to try and grapple with that, and what we're seeing on the plaintiff side for trying to make those EJ claims?
Yeah, so interesting. We've seen it earlier in other contexts, more specifically, like so for example, the permitting of hazardous waste facilities, that's been baked. Environmental justice has been baked into that for a while, and there's not as much litigation, though. There's just not as rich of a case law as there is for CEQA in general. But I would expect that it'll be potential for more case law for a while, and greater uncertainty and variability throughout the state until we get some Court of Appeal decisions and potentially Supreme Court decisions, just as people are groping with these environmental justice requirements.
Well, again, I want to thank you guys. You guys have been great. To one last question in the chat that I can answer, which is the county essentially decided on its VMP standards to take what will amount to several more months to study any change from the status quo. You still have to do a VMP analysis based upon the existing thresholds, which is a unincorporated county threshold. You still need to do a local mobility study, a local LMA based upon that. But so no changes, and no changes in the foreseeable next few months. And again, I want to thank you guys for your attendance. This will be sent out to there. For those that are interested, I know we have some potential overlap. You'll be getting an announcement probably in the next couple of days. We're going to have our tax credit webinar that's there. And again, feel free to also check out our website for any other upcoming SDNEDC events and resources that you can make use of. Thanks again for Latham, and have a great rest of your day, everyone.
Thanks,
everyone.
Bye-bye.